Started. Let's go on the record on cause number DC 1716115, Bank of America versus Pure Dentistry PLLC. Counsel, make your appearances.
Chris Fussman for the plaintiff, Your Honor.
Rich Roberts for the respondents.
Michael Stein. Oh, sorry, Your Honor. I'm the attorney who was appointed as a receiver in the case, Your Honor. Michael Stein.
All right, let's go ahead and proceed.
Judge, as you may recall, at our last get-together, the court requested that we brief whether or not the remedy of receivership is appropriate at this point in time in the case. This is post-judgment. It's not, pre-judgment. It's post-judgment. And 31.002 of the Texas Civil Practices Remedies Code controls. It's in two parts, and it has the turnover aspect, which orders the defendants to turn over all evidence of non-exempt assets that may be used to satisfy the judgment and the documents relative to those assets. And then it gives the court three ways to handle it. Either the court can take control of that process and handle it itself in-house, or it can have all those proceeds from the discovery served upon a sheriff or constable's office, or the court may appoint a receiver to handle the documents, to handle the assets, and to go through the process of the orderly exchange of the assets in order to satisfy the judgment. And so that's what we're here about. The court had previously, at our request, appointed a receiver and signed a turnover order. Mr. Roberts' clients were of the opinion that the order was not specific enough for them to know which of them were required to comply with the order. And so the receiver prepared an amended order that would make that clear, that it was to apply to all defendants and to start the process of gathering the evidence of non-exempt assets so that the judgment could be collected. We have briefed it, to the court. We have briefed the statute to the court. Basically, all we're trying to demonstrate to the court today is that by the language of the statute, the plaintiffs in judgment are entitled to the relief. The question is, how's it to be undertaken? And of course, the court gets to decide that. The statute uses the word may, and it says the court may do the following three things in order to effectuate the guidance of the statute to get through the process. So that's where we're at. And the question becomes, does the court allow the receiver to continue to work in the case and to handle the proceeds from the post-judgment discovery in an attempt to efficiently collect on the judgment, or does the court wish to undertake the process of the court's own volition, or does the court wish to have a sheriff or a constable appointed to receive the proceeds of the turnover order that the court has signed against the defendants? We argue that it is in the best interest of the case and in the most efficient method to allow the receiver to continue to work in the case, to allow the receiver to obtain possession of all the evidence of any non-exempt assets so that they may be distributed, so that they may be sold or liquidated, as the case may be. The receiver would be an agent of the court. The receiver would be subject to the court's direction should a problem arise, and the defendants would still have the right to come to the court if the defendants believed that the receiver was overreaching. That's where we're at, Judge, and that's our pitch to you, is that we still believe that
Mr. Fusselman, Mr. Roberts filed a brief a while back, the supplemental brief about, and he argues that you have not carried your burden, that I think the argument is the receivership is a harsh remedy, and you haven't carried your burden of proof to establish the receivership is necessary. So how do you respond to that?
Well, Judge, my response to that is, if we read the statute, it specifically says that the court can order this relief whether or not a specific non-exempt asset is specified. It's enough, Judge, to look at the record and to ask ourselves, is there evidence of a non-exempt asset? And I ask you to please forgive me. I'm at the tail end of COVID, and I'm trying to keep my thoughts together. But I mean, we do have an attorney representing the defendants here today. And so I think we can presume that there's some type of asset available to retain counsel that could be used to pay toward the judgment. And beyond that, there is in the court's records in the district court, I think the 95th, there's a case pending, DC 2211135, in which one or more of the defendants is a plaintiff seeking money from other people. And certainly that is an asset that were it to be realized, could be used by the receiver to help to resolve this case and toward this judgment. So we think, based on what the statute says, Judge, we believe we have met our burden. I respect Mr. Roberts, and I know that he's a good lawyer, and I understand his argument, but I don't think the burden that we have is the burden that the defendants would like for us to have. I think the burden that we have is spelled out in the statute, and I think the statute says that if we can see the prospect of a non-exempt asset, and in this case we actually see evidence of it, then we have the right to have a receiver appointed to take possession of that non-exempt asset, unless it's an asset that the court or a constable can take and liquidate on their own. And in terms of an interest in litigation, that's going to require a receiver to handle, Judge. There'll be no other way efficiently to handle that. Certainly not through a constable, and I don't think through the court's personnel involving other cases and other courts.
Mr. Roberts, response?
Thank you, Your Honor. So we agree with some of that and we disagree with others of that. So Chapter 31 clearly does apply. And we agree that receivership is a potential remedy. But that, because it's a potential remedy, does not mean that it is an automatic remedy. And we provided, Your Honor, with cases in our supplemental brief saying that. So as Your Honor noticed, when we last argued this, the original order had been granted ex parte, which is permissible, but it had some deep flaws. Most notably, it didn't even really specify to whom it was addressed. It was clear that it was a form order from a prior case that wasn't specified to this court in this matter, and it's just one that they're trying to churn through the system. And given how harsh of a remedy receivership is, that's a real problem. And so we raised some of these problems to Your Honor. Most specifically, first off, their threshold. Receivership is a potential remedy, but it is not an automatic remedy. And they must show, and we provided Your Honor with some cases in our brief, and I can read them here into the record, but to obtain relief under the turnover statute, the party seeking relief must show that the circumstances exist permitting that relief. And in the case of a receivership under 31.002, they must show that there is some non-exempt asset. And look, I'll be candid here on the record. That's not an enormous showing. That it isn't, but they haven't made it. There is no record. There is no record of non-exempt assets, and to my knowledge, there are no non-exempt assets. I suppose if we got into discovery, that might change, but to my knowledge, there aren't. These people have structured their lives to protect themselves from creditors, and that's totally permissible. And they certainly presented no evidence of that to Your Honor. So one, they just fail outright. I mean, they just haven't made their showing. Beyond that, Your Honor raised this we raised it at the last hearing, and Your Honor asked for more briefing on this, but the form of the receivership order that they have proposed, we believe to be deeply flawed. And we sort of outlined this in our supplemental brief, and I don't think that Texas law is really very clear on this. These post-judgment receivers, there was a change in the law that's fairly recent that opened them up. They were kind of not a very common remedy before that change, and so you're seeing more of them, and I don't think the law has quite figured this out. But essentially what the law in Texas seems to say is you can have a receivership under the common law, or you can have it under a statute. And if it is under a statute, then it's bound by the terms of the statute. Most receiverships in Texas come under Chapter 64. That's the historic general receivership statute. And it is much more substantial than the post-judgment receivership statute. It has requirements on who's qualified to be a receiver. It outlines the powers and rights of a receiver. It's much more substantive. And the courts, as has been clear, we've pointed out to the court in our brief, they've said, look, these are different, right? Normally it comes up where somebody wants a Chapter 31 receiver. And then the other side objects and said, well, you got to prove all the Chapter 64 stuff. And the court said, no, they're different. Chapter 64 is 64, 31 is 31. If you look at what the statute actually says, the statute in Chapter 31 gives the receiver very little power. It basically just says the receiver can take possession of the non-exempt property and sell it. That's it, period. That's it. And so you see these cases, now that there's been kind of a change to allow this, that they come in and they're seeking these broad Chapter 64 type of receivers. And we pointed out a number of circumstances in their proposed order where the order would give the receiver power over non-exempt assets. And that is something that Chapter 31 clearly does not contemplate. It clearly doesn't. Here's what they want. What they want, and I get it. I mean, I've done both sides of this type of litigation. They don't want to have to serve discovery. They don't have to go through fights. They want to appoint a receiver who has superpowers over everything and can come in and ignore everybody's rights and, as the agent of the court, be on the side of the court, which is much harder for us to contest, and just go collect everything and then figure it all out when the dust settles. And that's not what the statute provides. And it would be a gross violation of my client's rights. What the statute says is the court can order a receiver to take possession of the non-exempt property. And I can pull it up if Your Honor would like me to show it to you on the screen. And that's it. Now, the Texas Supreme Court, they issued a form order, and that form is not binding in this court. We're not making that argument. It would be binding on a justice of the peace if they were trying to do this. But nonetheless, that form order, I think, gives a good idea of where the Supreme Court's head is in these things. And the Supreme Court has a much more limited form of order.
So let's kind of look at, this is their proposed, I think, most recent order. Is that not correct?
Well, that is an amendment. Your Honor would have to look at the original order because they're asking basically to amend the original order. So that is just going to have 2 paragraphs. Our position is that the original order didn't apply to our clients because it didn't name our clients, didn't name anybody in the parties. So we'd have to look at the original form of order, which I believe I have. If Your Honor would like me to pull it up, I have it here.
Yeah, go ahead.
Let's see. Sure. It's disabled, Your Honor.
Here, let me turn that on.
Judge, this is Fusselman for the plaintiff. I mean, if it simplifies matters, we intended to live with Mr. Stein's proposed order as being the order for the receivership going forward, with no other requirements that were mentioned in the original order. So it is.
Where is Mr. Stein's or Mr. Roberts' proposed order?
Mr. Stein's, Judge. Mr. Stein had submitted a proposed order that he hoped would comply with, or at least
when was that filed, so I can take a look at it?
Sorry. It's a supplemental order. All it does is clarify who it is, and it adds the statutory language required by the Supreme Court in their recent.
Is that not what I just showed you guys, or is that?
Yeah, that is the supplemental order. It is to be read with the original order.
Okay, I apologize, Judge. That's my fault.
Okay.
I misunderstood.
So this order here would supplement the original order that had the problems with it, that had the wrong names and everything?
That's correct, Your Honor.
I mean, wouldn't we need to change that original order to clarify that, because it had my recollection, it had the wrong names in it? Wouldn't we need to amend it and wipe that one out and make a new one?
I think so, Judge. I think it said defendant in a couple places rather than defendants.
Okay.
And that was alleged to be the causer of the confusion.
It said respondent, and respondent was not a defined term in any document.
Okay.
It certainly could be clarified, and we'll agree to clarify it.
Okay, so Mr. Roberts, if I'm not going to sign anything today, but assuming that they correct that and they add this, what is the problem with the order then?
So we stand by the fact that they haven't made their threshold showing to obtain any order whatsoever. But
Okay.
aside from that, from the form of the order as it stands, there are a number of provisions that we believe are just overbroad, that are not limited to non-exempt assets and that aren't authorized by the statute and really just aren't justified in these circumstances. And we pointed out a handful of those in the brief. I'm happy to walk through those with Your Honor if you would like to.
So I think there does need to be a receiver. I don't have a necessarily a problem, but I am concerned that it's not over. I don't want it to be overbroad. I want it to comply with the statute. And so I guess my question is, how do we need to fix this in order to make it comply with the statute, assuming that I've found that they've met the threshold?
Well,
Your Honor, Chris Fussman for the plaintiff again. If I may make this suggestion, that Mr. Stein has been appointed receiver in the case, and I would suggest it might be appropriate to have Mr. Stein submit a proposed order to the court, which he believes is within the statute and within the guidelines of any common law that might apply, and give both attorneys an opportunity to comment on that, and then perhaps have a last hearing to formalize that final order.
I think that makes sense. What I would suggest, and I know that this has been going on for quite some time, maybe we reset this for a week. So the next Monday, it'll be remote again. Mr. Stein, how much time would it take you to get us a corrected order with one order amended, fixing everything?
I can do that in a day, Your Honor. I will. It's a little challenging. I've been doing this for 20 years, over 20 years actually, and I think Mr. Roberts' argument is unique, and but I can tell you, in all these years that I've been doing this form of order has been approved by a variety of courts, whether it's trial courts or appellate courts. So I think it's an interesting argument to say, oh, you're limited to only being able to have the authority to take possession of the non-exempt property. And so the order that I would propose would be similar to what plaintiff's counsel presented to the court. In fact, my order tends to be broader, but the idea here is to please the court and have an order the court is comfortable with. So what we've heard today is that Mr. Roberts' clients are savvy in avoiding paying creditors. They have set up their lives to avoid doing that. What we've heard today is there is, for certain, at least one non-exempt asset, that being a lawsuit. And that is one in which Mr. Roberts is counsel for one of the plaintiffs who is one of the debtors in this case. So I can certainly prepare an order, but I don't really know what the court is looking for. In my view, as a receiver.
So Mr. Stein, what I guess the disconnect here is that Mr. Fusselman, who's your lawyer, has said that there's defects in the order. I want those to be fixed. And I want to make sure that it strictly complies with the terms of the statute. That's what I want. So that's what needs to be fixed. And it may be very minor, just stating respondents to respondent to respondents and clarifying who that is. It may be as simple as that, but I want a solid order that incorporates the supplement and the original into one order that is that deals with the defects that your side has already admitted. So is that clear?
That's clear to me, Judge.
Yes, Your Honor.
Okay. Thank you, Mr. Stein. What time do you guys want to do this next week? And if you can get an agreed order to me, that would be great. And we don't have to have the hearing, but just so we have a placeholder.
Your Honor, I'd be glad to do it at 3 o'clock again if that works for the court.
That works for me, Mr. Roberts.
I have a hearing at I have a hearing in the county court at law 4, but that's in the morning, so I can do the afternoon on Monday.
And that'll be on Zoom. Mr. Stein, does that work for you?
Yes, Your Honor.
All right, guys, let's get it fixed and we'll get this thing taken care of. So we'll see you guys. Rhonda, did you get that? We'll reset this hearing to next Friday at 3 o'clock. I'm sorry, next Monday at 3 o'clock. Rhonda, are you there?
She's on mute.
Okay, you said next Monday at 3 o'clock?
Reset this hearing to next Monday at 3 o'clock.
Got it. Okay.
Thank you, guys. We will